Take a look at this. Ongoing legal battle intensifies with new allegations. After a protracted conflict with the Securities and Exchange Commission, Alderodi discovered some intriguing similarities between the behavior of the SEC and the absurdities depicted in Franz Kafka's novel, The Trial. He accused the regulator of engaging in activities that were illegal. Ripple is of the opinion that the approach used by the SEC is unfair and lacking in transparency, which is reflective of broader problems that other cryptocurrency companies such as Robinhood and Coinbase are experiencing through the filing of requests to seal crucial financial documents. In preparation for their release to the public, Ripple has taken measures to protect its interests. The records in question contain essential information regarding earnings, revenues, and expenses, as well as the discounts that were offered to institutional investors when XRP was sold to them. It is Ripple's contention that the disclosure of such information would be detrimental to its commercial interests and would put users' privacy at risk. Following this, the Secretary of the Securities and Exchange Commission has demanded that Ripple pay a penalty of $2 billion for allegedly selling XRP to institutional investors. The legal team representing Ripple, on the other hand, maintains that any civil penalty should be limited to a maximum of $10 million, stating that the SEC's demand is not justified. Furthermore, they argue that Ripple should not be compelled to pay this substantial sum by employing illegal strategies because there is no loss of customers. The criticism offered by Alderodi bring to light the greater issues that exist within the cryptocurrency industry between the enforcement of regulations and the operations of businesses. The Securities and Exchange Commission has provided Ripple and other cryptocurrency companies with what they describe as inconsistent feedback, which has made it more difficult for them to comply with regulatory obligations. As a result of the legal dispute involving Ripple, moves within the United States government to restrict the SEC's regulatory authority have been brought to light. In an effort to limit the impact of the Securities and Exchange Commission on cryptocurrency legislation, Alderodi has lauded collaborative efforts in the House of Representatives. Notably, the House of Representatives recently voted to repeal the Staff Accounting Bulletin 121 CB 121 issued by the Securities and Exchange Commission SEC. This bulletin requires financial institutions to include the cryptocurrency holdings of their customers on their balance sheets. Ripple's lawsuit against the Securities and Exchange Commission is major for the cryptocurrency industry as a whole. It is important to note that the SEC has also questioned Ripple's future stablecoins, which makes their aim more transparent. There is a possibility that the conclusion will establish precedents for the regulation of digital assets. Finally, the allegations that Alderodi has made against the SEC are unmistakable and important. The triumph of the SEC will have a negative influence on the cryptocurrency market, since the classified status of XRP as a security will force many other assets to be burned while they wait for similar rulings. New accusations have escalated the current legal struggle between Ripple and the SEC. Predicting the future of the Ripple versus is an impossible task. The XRP community has been anticipating its victory for quite some time, and the scenario continues to evolve with each passing day. Despite Ripple's claims that the SEC is trying to regulate cryptocurrency too heavily through vague laws, the Securities and Exchange Commission has been accused of having dishonest attitudes and unfair practices. The chief legal officer of Ripple, Alderodi, has recently spoken out against the way the SEC has dealt with the XRP litigation. The issues plaguing the Bitcoin sector and the unfair practices he perceives have been brought to light by him. Innovation should not be seen as a partisan issue. On Gensler's Securities and Exchange, I'm relieved to see that Republicans and Democrats can agree on something. Following a drawn-out battle with the SEC, Aldrich drew some interesting parallels between the agency's actions and the ludicrousness in The Trial, a novel by Franz Kafka. He claimed that the regulator was involved in illicit dealings. Other cryptocurrency companies like Robinhood and Coinbase are facing similar issues, and Ripple believes the SEC's approach is unfair and lacks transparency. As part of its legal strategy, Ripple has requested the sealing of important financial records in order to prevent their public exposure. As a precaution, Ripple has taken steps to safeguard its assets. Information on earnings, revenues, and costs, as well as the discounts granted to institutional investors when they purchased XRP, may be seen in the records in question. Disclosure of such information, according to Ripple, would jeopardize user privacy and hurt its business interests. In light of this, Ripple has been hit with a $2 billion penalty by the SEC for selling XRP to institutional investors. Conversely, Ripple's legal team argues that SEC's demand is unwarranted and that any civil penalties should be kept at a maximum of $10 million. They go on to say that since Ripple isn't losing clients, it shouldn't have to pay this huge money through legitimate means. More serious worries about rules and regulations. The bigger problems in the cryptocurrency market between the implementation of rules and the functioning of companies are highlighted by Alderoty's criticisms. Inconsistent input from the Securities and Exchange Commission has made it harder for Ripple and other cryptocurrency startups to meet their regulatory duties, according to the company. A reply from legislators, U.S. government efforts to limit the SUPU's regulatory power have come to light as a consequence of the Ripple lawsuit. The House of Representatives has been working together, according to Alderoty, to limit the power of the Securities and Exchange Commission on crypto legislation. Particularly noteworthy is the recent vote by the House of Representatives to nullify the SEC staff accounting. Financial institutions are obligated to disclose their customers' cryptocurrency holdings on their balance sheets per this advisory. Concerning the Bitcoin sector, what does this imply? For the cryptocurrency market at large, Ripple's lawsuit against the SEC is a huge deal. Note that Ripple's goal is now more clear because the SEC has also questioned their future stablecoins. Possible precedent for controlling digital assets may be set by the conclusion. To conclude, Alderoty's claims against the SEC are clear and significant. Due to XRP's classified position as a security, many other assets will be burned as they await similar verdicts, which will negatively impact the cryptocurrency market if the SEC triumphs. Stewart, Ripple's chief legal officer, has likened the SEC's actions to the blunders depicted in the book The Trial as the company continues its legal battle with the U.S. Securities and Exchange Commission. Over the course of the Wells Notice investigation, Alderoty blasts so for what he sees as XRP's unfair treatment. This points to the problem's pervasiveness and the fact that it impacts other cryptocurrency companies like Coinbase and Robinhood. A cryptocurrency called Clove Ripple has spoken out against the SEC's contradictory policies. Throughout the continuing proceedings, Ripple has maintained its claim that the SEC has handled the problem in an inconsistent and unfair manner. In a scathing critique of the regulator's opaque and capricious actions, Ripple's chief legal officer drew a comparison to Kafka's writings. This case is representative of the broader challenges that cryptocurrency companies face, according to Ripple, and the SEC often gives them conflicting remarks. Robinhood and Coinbase aren't the only companies that have said they've run across regulatory roadblocks. The Securities and Exchange Commission is still pursuing Ripple with heavy fines in mind. For the sale of XRP to institutional investors, the SEC is seeking more than $2 billion. In response, Ripple has filed and sealed documents that detail the harm that could come to its company interests if certain financial details were made public. Information on profits, revenues, expenditures, and the discounts offered to institutions when they purchased XRP has been asked to be redacted by Ripple.